Abum ena esibu so Chairman Wontumi ene yewra Hannan, former Buffer stock CEO and MPP. There's a very, well, I say shocking or explosive. I think it's a very interesting update on the cases. You say the judgment in the Wontumi Samreboi case in the court no schedule ene 20th July. Initially, nanke ye 3rd July. And because you're attaching so case in the last, cancer court no man mere. Now one steady case and on find the final and as a concluding statement. Court no. Last week, I know the court and they say what to say. And already case no. One who says sections near the Bawumia the Minerals and Mining Act. Never be woman here Supreme Court interpreted the court no crowd the on judgment on Supreme Court and quadja them. And remember, now Sunday another update about. I don't know what to make of it because it's interesting. Here Hannan also, the former Buffer stock CEO, are charging in the 78 million CD issue on Nigeria. On also a 5-page document a comma attorney general. Say a tochana do. Aden. Ni you can be BNI attorney general unhuye. When attorney general keke minister of justice. Ni a question in your justice. Kachira unkola hanu munya inse munu no mudi. Menya kola asa. Na papa pani ye dodo mi se ade ni nyina meka e de akere nti ene no enye obi a video ye nko an ye be ya analysis no in this episode ma so be subscribe ma subscribe ya na click bell notification me the video be to ma be hu na wetima hwe bu wi a you will certainly have a comment. Feel free, leave that comment in the comment section. We are so be ko Goldberry construction limited do dan episodes no sasen kratasem the documentations related to your house in Goldberry in the BD stage man in am so your flood victim Accra Central Volta region and here renovation works via for Goldberry your BD stage man in the am o your brain pomba ho addiction related issue trauma related issue aged care ko brain pomba ho obehwo ne bibia aye kama ediama. It's 5:20 a.m. on my clock. Let's go into the issue. Let's start with Chairman Wontumi case. Last week na me bon kroma I say Chairman Wontumi case say na me kan we intro the case judgment na ye court ni ntie anaso on find the verdict on the constitutional matter Samuel Atta Akyea has raised. Near no so there between the court and international and then you bet to say be a court of the judgment beba. And answer court be ruling on the matter. So okay, be on Atta Akyea something go Supreme Court. And answer the Atta Akyea above for the court to make us on any have been to offer ruling on Wednesday. Atta Akyea proposing. Then tina year Samuel Atta Akyea propose say judgment in Wednesday. Enuni enra. And a team a cross check letter no. It is true. It's a truism. I mean, Kaima or say. The Register High Court Criminal Jurisdiction 4 Accra. Dear Madam, no bo suit in Bibi say. We act as counsel for first and third accused persons or applicants in the instituted matter. We respectfully write to inform the court that the substantive hearing of the first and third accused persons application for deferment of judgment and constitutional referral has been scheduled for Monday on 20th of July 2026. We regret to state that the learned counsel who is seized with the conduct of the matter, Mr. Samuel Atta Akyea Esquire, is presently outside the jurisdiction of the Republic of Ghana on a proud personal engagement and will return to the country on Wednesday, 22nd day of July 2026. So almost Atta Akyea to kwan uni kurumu ha. Nti say lawyer no di asem ni kurumu na say ye be ya asem no Monday dia as a judge ye ika to tobo na womra Wednesday oba court. And of course can say in the circumstances we respectfully pray that the hearing of the said application to be adjourned to a date after 22nd day of July 2026 to enable learned counsel who is fully seized with the conduct of this case and is best placed to move the application to be present before the court. We respectfully assure the court that this request is made in utmost good faith and not with the intention of delaying the proceedings, but solely to afford the first and third counsel the opportunity to have the application argued by counsel with conduct of the matter. We shall be grateful if the request is placed before the learned trial judge for her consideration. We thank you for the usual corporate signed Charles Boache Esquire, Zoe Akyea and Co. And see, the concrete to for Bawumia say you were attached to kwan. Case no so no di ama Chairman Wontumi e besrew. O pese dey na be judgment na no friends will be can obe move motion say we raise the issue say based on article 1911 say wo charge will be a so offense near define penalty chassis. Atta Akyea contention say the Minerals and Mining Act in section 14(1) no vague do overbroad inconsistent. Section 59 also no penalty ni ho and 41 the penalty ni ho. Intim so ka se penalty ni 1992 bi a na adwene insisi so sa vague ye ka vague eso dodo nti ase no wachiri dodo enti enko Supreme Court yenko invoke the original jurisdiction of the Supreme Court article 132 because the original jurisdiction of the Supreme Court basa mbra no aye kesene we yitrim ne ehio bia church ya e Supreme Court ye church ye fa sam ne nko enti no sa Monday ye ne no be mo ni ha wakodi akwantum enti any later date apart from 22nd ezi ewura attach abeba 22nd ye Wednesday enti ye sero say bia Thursday Friday kura na oba ne atena so on can so person delay process no wo pese yewura Wontumi and then the company enya a fair hearing in court. That is number 1. I'll share my view on all these matters later. Yanko number 2 yewura Hannan and no a 5-page document and yasem keto America na miti beja mosonfo meka ma ti meka na brofo edu ba bia na me de abetwi enso de ama me audience omonti asen. Now so what title petition go say petition to the Attorney General Minister for Justice of the Republic of Ghana on the continued harassment, torture and injustice in the prosecution of Hannan Abdul-Wahab. On one natural letter we nya ne law from on one natural or say I Hannan Wahab currently on trial before the specialized court Accra hereby submit this application to respectfully bring to your attention a series of acts of grave injustice, plain harassment and torture are suffered since the commencement of the case filed against me by the state under your direction. I am compelled to write to you directly because you have ignored the letter written by my lawyers dated 9 July 2026 complaining about violations of my rights and unlawful seizure of my money by EOCO. I wish to state unequivocally that I am innocent of the charges which have been leveled against me. I have committed no offense and I am prepared to subject myself to any fair and just judicial process to clear my name and vindicate my reputation. I have full confidence in the judiciary and the rule of law, and I believe that given a fair trial, a fair hearing, the truth of my innocence will be established. It is for this reason that I find the conduct of your office and agencies operating under your direction, including EOCO and BNI, so deeply troubling, as they have systematically denied me the fair process to which I am entitled under same constitution which gave you authority to prosecute. Say, who age? 9th. Na me troll letter bro. True me lawyers go Fred me say, Ebra ye stopping me say me kuyi. Me se kebi ka ho. £6,700. Besi ame koje some de koheme ni ebra court na ma me kwan se me ntu kwan me trouble letter bra wan fi me na ade na mo ye no enya papa wo age no BNI under you EOCO ade mo ye no wan hu biba wayi wani enya de papa ti me de letter na ebra obi o me ami tropity am lawyer tron wan fi no so ne go freda mo problem na me nim dia me dem de letter ebra sa ade na mo ne me ye no enya fe na me sign miti ade na ade ato me so minim ho he minni boni bia me sign miti samoma process na fe nkwa Ghana fo nyina bi so me Hannan menye bibia. And of course, say the actions undertaken by state agencies under your authority have consistently violated my fundamental human rights, undermined the rule of law, and brought the administration of justice into disrepute. I'm compelled to bring these injustices to your attention in the hope that you will restore the integrity of the legal process. In fact, the prosecution so far can be described in no way than plain persecution. See, I was initially arrested on 25th June 2025 and kept in custody of EOCO for more than 2 weeks. Bail was purportedly granted to me under unjustified conditions calculated to detain me beyond the constitutional limits without being processed before a law court. I struggled to justify the onerous bail condition in the sum of 60 million cedis to be justified before I was eventually able to secure my release. Subsequently, I was constrained to remain in EOCO cell for more than 2 weeks. You held a press conference in which you publicly condemned and defamed me, even before charges were leveled or filed against me, before I had been able to afford an opportunity to respond to the allegations in the court of law. Frankly, I found the press conference to be without precedent and deeply disturbing. As the Minister for Justice and Attorney General, I had expected that you would uphold the highest standard of fairness and due process. Instead, you subjected me to public ridicule and condemnation before my case had been presented to a court for any plea to be taken. This premature and extrajudicial pronouncement of my guilt constituted a grave violation of my right to be presumed innocent until proven guilty. Respectfully, Honorable Minister, your action did not accord me the fair trial to which I am constitutionally entitled in the democracy we have chosen to govern this country. The right to fair hearing, including the presumption of innocence, is a cornerstone of our legal system and a fundamental right guaranteed under Article 19 of the 1992 Constitutional Republic of Ghana. By publicly condemning me before the judicial process had even commenced, you set a dangerous precedent and eroded public trust in the fairness of the justice system, which was to try me. Subsequently, I was charged before the High Court Criminal Justice for presided over by her ladyship, Kukuvite, where I pleaded not guilty to all charges, firmly maintained my innocence. I was granted bail in the sum of 100 million with 6 securities, 4 of whom were required to be justified for landed property. Additionally, I was offered to deposit my passport with the court. I was placed on the stop list at all entry points and or at all entry posts and points of departure. These bail conditions were manifestly unreasonable, oppressive, particularly as they were far in excess of the total sum I was alleged to have misappropriated. As a result of these onerous terms, I was compelled to remain in custody for further 2 weeks whilst I made strenuous and expensive effort to justify the bail. Say, what told you now? Who are Minister of Justice? So by a press conference, that 20-day trainer in Manila, a judge me, the assembly to told me so. Asam kwa ne fen kokot gumanima ase sada ye you defame me wanyade later mo de me kokot mo de me kokot mo sa me ma me bail e ma me kodam 2 weeks ba ansa kra na mo de me kobo ne yo kwache me deda no so makodam 2 weeks sa tade na mo de ye me no eni enyan dodo ye wura Hannan na e kase mesre mo the kind of fun match mu twi tema mo ndwensa me ana me bu mitima ka bibia pato. I say, as you remember, on the 5th day of May 2020, so approximately 7 months into the trial, you withdrew all charges against me. This decision followed unsuccessful challenges mounted by my legal team against several procedural irregularities that had planned the prosecution's case. The court accordingly struck out the charges and discharged me. However, immediately after I was discharged by the court, officers from EOCO, accompanied by heavily armed commandos, wearing and welding military grade weapons stormed the court premises and arrested me. This drastic and excessive show of force was completely unnecessary, given that I have always been unarmed, have never posed any threat to anybody, and had been regularly reporting to EOCO in compliance with my bail conditions throughout the pendency of the case. I was treated as though I was a dangerous armed robber, notwithstanding my consistent cooperation with the authorities and my unblemished record of compliance with all court and EOCO directives. Following this arrest, I was transported to EOCO cells. My lawyers were informed that they should follow the officers to EOCO, where they would be permitted to see. However, upon arrival at EOCO, my lawyers were met with complete obstruction. Despite the fact that EOCO was fully aware that my lawyers were coming to see me, every official they encountered pretended not to know that I had been brought to the premises. The lawyers were denied access to me for an extended period in clear violations of my constitutional right to legal representation. Whilst in EOCO custody, I fell ill and required urgent medical attention. I was taken to the hospital without the knowledge of my lawyers or my family, even though EOCO was fully aware that my lawyers and family were present and waiting to see me. At the time I fell ill, it was critical that I needed the support from my family. The decision to transport me to the hospital without informing my family or lawyers was not only insensitive, but also constitute a further violation of my fundamental human rights. I later got to know that after waiting till the close of the day, EOCO, through its sales manager, boldly stated that it was past visiting hours, and my lawyers could not see me, despite the fact that EOCO had been notified as early as 10:30 a.m. of my lawyer's request to see me. This made it clear to me that EOCO had deployed a strategy to deprive me of my right of legal representation whilst in detention. Or say, Monimi ko EOCO after some mujai first case in the mono. Ye discharge me kwa na mosa be che me say new evidence abai no ne de born na rent ni wo me. Yes ye kwa me yare me lawyers wo ma mom lawyers amane me yere wo ho ma mo na madam de me court mo ne ko na bibi kwa ya me aka mbe ka den later mo twen ya ma bra visiting na wetwen mo ka kire me lawyers say mo humi a enye yie ma anya ade okoso ka say let them know what or say and or the UK the ne ba ka so obeko court any bibia Attorney General Kotra di Facebook were very very unhappy with Yera Deputy Attorney General Justice Ram side your Kotra court any bibia mama mo ne tofa kakrama why or say on 29 June 2020 says the High Court presided over by his ladyship Achibonga granted me permission to travel to the UK for a scheduled medical appointment with my optician after being satisfied that there was nothing that showed that I would not return to stand trial. I was offered to leave another mabon kuna makrada say the letter no the command go for ya dam letter yakum da think yen skip we yen skip we yen skip we na yen call the concluding part no yen call concluding part 32 no say in light of the above I humbly pray for the following. 1. I request that you and your officers refrain from making any further public comment which are defamatory and prejudicial to my case. I am tired of the incessant disparagement of me by your outfit and EOCO. 2. I implore you to ensure that all future actions in this case respect the rule of law, the authority of the court, and the constitutional right of all accused persons. 3, I petition you to direct EOCO and BNI to stop this pattern of harassment and intimidation against me and my family. And zero Hannan say Attorney General near mammy and son, never bone crony in the match that we any new things. Now 3 hours and say, woo, Attorney General be a more public ye caught and be cassa de woman mass the jay and you suba papa. Catch the EOCO ni be and as omunya intimidation no. Cause me bail and what the man any condition. My diso. Me ba court bram kasa memra court me ba EOCO bram kasa nti me nyo obi asa am robber mo be cheme ana mo ye me bibia mo time mani ye mani ya asa me ye Ghana ni mo nya ne mo ye no. You see, my view on this is that everybody knows me. I've always said that take the person to the by respect is right. And today then is the na can Saturday no say almost 2 days no be nyan lawyer there and yasem papa. You see, and these things you don't need to be MPP to be NDC. It can be you, it can be me. Me kwadwuma bibi betimi ase me nko police station na me hia lawyer na ese ma me hu lawyer enya de papa prosecute the man so suspect is we di boni bi nko ade prosecute the man but afford him his legal representation so that no can one court so that e kodu ba bi a emeye Camilla de ne de day na okubo reason say na me so na lawyer ni wo and I say na no na the noise bi braba. Afford the person as lawyers. Let the lawyers be present when you're interrogating the man. Let the lawyers be present when you're taking the caution statement. Let the lawyers be present when you're taking the plea. Very, very important. Say that chance in been to be make us we create a kangaroo process. Now my lawyer knew and that's kind of a thing. So afford him the lawyers. It's also within his rights to report because you see that's why some people have even argued that the Ministry of Justice and the Attorney General should be separated because all these agencies is questioning and raising issues are under the Attorney General Department. What I say. So it's a very, very tricky situation. They work in tandem with that. It's a very tricky situation. But I also get him because as Minister of Justice, you need to ensure that there's fairness. I think that if you feel that some of these processes and if indeed they are true, and in fact, the precedent where EOCO, one of the matters, Roman admitted and the lawyers now watch it because no handle that case near then. I think that maybe going forward, these things need to exercise our time. It shouldn't just be say, oh, enkoso. Because that actually, if you're not could before for be or not there, if you open us and it shouldn't happen that way. Prosecuting back in fair trial. On Atta Akyea, I find it very interesting. Interesting in the sense that why would the letter come out? Because you're attached, I'm just saying no, I'm going to 2 coin. So I find it very, very interesting. But as I always say, when it comes to ORA and any other criminal matter, any lawyer will do his best to keep his client out of jail. The state has proven this case. Wontumi said he won't speak. The court said, now you have questions to answer, come and speak. We all seen the process that have gone into and the appeal groups on your case and be attaching adjourn and there. It's not to be a mechanical say, ORA no. A back check. I always say this in the videos that my dream yes at the end near neighbor. It's in move near cut a fast track court and there knows that people have issues with these specialized courts and all that. But it is interesting and we only hope and pray to hear what the judge will say today. Say Obejia Tum say yen suspended and answer the judgment beba in the Wontumi matter. I try to speak to my lawyer this dawn. Or catch him say your lawyer doesn't necessarily have to be there. Because he's being represented by the chamber, Zoe and Kone, any lawyer from the chamber can be present in court and also because as soon concluded. So it's not about the matter as having almost chassis for written statement grabber. So it's not about a fresh matter. So anybody in the chamber come there. That's what my lawyers tell me. And I always say that maybe lawyer view and just sacrosanct. Any lawyers, two lawyers can read the same provision in the constitution and come to different conclusions of the matter. So don't take my lawyer's view as sacrosanct. But that's what he's telling, because I'm not a lawyer. So I cannot give a law point of view on my own authorities. There be. I need to seek education on that. And I'm a strength. So that's that. So these are the updates on the two matters. I don't know where you stand. I don't know what you make of everything. I find it very, very interesting. On the Atta Akyea side, on the Hannan side, you know me when it comes to human rights and everything. If indeed it's true, let's do better the next time and afford him the courtesies whilst prosecuting him, and also maybe recover the proceeds that allegedly he has stolen, totaling to 78 million cedis. Me view, no. What's your view? Share it in the comment section. We are now subscribe. Subscribe now. Click the notification. Me the video be to my behu. No what's my favorite. So be show musu ye edi amame. Me hiao o my Ghana and so hiao. Bye bye.